I'm sorry, I'm speaking.
I'm sorry. She was asking me a question, so if you just let me. If you would just allow us to speak for once.
So I did not get any type of worksheet from.
It sounds like it. I sent an email. I know that you've been in court, but so we were filling out the affidavit for Mr. Breland, but considering that he is self-employed and has his own company, he has, like, say, his maintenance records. He has to keep them in the truck because of DOT and stuff like that. So we were having to get a lot of the stuff together so that we could accurately fill out the affidavit. So it was taking longer than we thought. So I have not submitted one because I wanted to make sure that we got the information right. I understand there's probably going to be, you want to do an award of child support. But we understand that, he understands that, and has been paying for his children since they were born. And so I had originally sent an email just saying that if we could get, send it to you over the weekend or first thing Monday, so that way that we could get all those records and everything together. Because, say for instance, last month alone, he had, a breakdown where he had, I think, like $13,000 worth of expenses for the truck, stuff like that we just didn't want to, since we've got to do the gross and net, and it's not just a paperwork of a W-2 or anything like that. It was just, we wanted to make sure we got it right for you. Yes. Was she?
Yes, so, Ms. Montgomery.
Yes, Your Honor. Good morning. I guess we're in afternoon now, so good afternoon.
No, I know. I printed out your worksheet and I said it. All right, Ms. Free, what'd you do with it? No, I printed out. So, I'm not real sure. So I know before he was paying $900 that he said was paying everything else. Now, I believe, according to my notes, that Ms. Montgomery claimed yesterday that I think she had said, or her client said, he'd made about I think $13,000, something like that a month, 13, 14.
That he paid that?
That Eddie made, and then he made that.
I'm sorry.
That is correct, Your Honor.
And that's what they're saying as far as the gross, but he has his own business, so obviously he has the expenses of the whole entire business too. So that his net income is not that every month.
Yeah, well, that's the thing is that with child support, you got to go by his gross. I mean, when you're self-employed, you can take some of the.
All right, guys, buckle up. This isn't your average courtroom session. Today we're inside Judge Raquel West's domain, where excuses crumble and reality hits hard. From the moment the camera pans across the courtroom, you can feel the tension. Defendants shuffle nervously, hoping charm or confusion might save them. But Judge West? She's not here for games. She's here for justice. What's about to unfold is a masterclass in accountability, where every word counts and every second drips with consequences. Let's dive in, because this courtroom doesn't forgive.
Things out, but not all of them. Right. He had testified that he made about five. Let me pull up my
right.
Two. Oh, there it is.
All right, here.
I think his testimony was he made like 5,000.
I believe he said 3 to 5.
3 to 5, which is on the child support worksheet. There's a place for self-employment. So I just had a couple of questions on this. So on here, I saw one that said separate assets and wife. So is there $16,000 in a joint checking account, Ms. Montgomery?
No, there's no joint checking account, Your Honor. The only thing that we provided was my client's financial affidavit.
You're going to have to speak up, Ms. Montgomery. I'm so sorry. I'm sorry.
Okay. All right. Can you hear me now? I was saying that no, there is not a joint account. What you received was the DERFA for my client only. And that did not include Mr. Breland's finances on that document.
Because I saw where it said bank account. Where it said bank account, it said, I guess you typed out joint checking account. And it went over and you put separate access, separate wife, you put 16,000, and you said a separate basis of claim, you put 200.
Okay, I think that was supposed to be amended. So if it was not, then I apologize for that.
Was it like 1,600?
Yeah.
Okay. I looked at it and I was like,
no, my client wishes, but no, unfortunately, that's not the case. Your Honor, we just want to make it clear that this was a temporary protective order hearing. And, obviously as one of the requirements when there are minor children involved is that the parties are to provide a DERFA along with their child support worksheet before the hearing. And so our position is that we would like a ruling today along with an amount of child support because the children, Mr. Breland has gone over 30 days without providing any sort of support to the children. And we really do not want to file an abandonment claim against him and have him put in jail. So if the courts could go ahead and...
Our first case kicks off with Jacoby Chambers, a man on probation for aggravated assault who somehow thought rules didn't apply to him. Judge West stares him down, unimpressed. "You were given a second chance," she says, her voice cutting through the air like a blade. Chambers fumbles excuses, job stress, bad luck, everything but responsibility. The judge leans forward, eyes sharp. "That's not how probation works." You can almost feel the courtroom shrink. Chambers realizes too late that mercy has an expiration date.
And put in an order that would avoid us going after him.
And Your Honor, we just said that we understand that there's going to be a ruling today and that Mr. Breland is understands that the court is going to award an amount of support today. So I don't see that we've raised any objection to that.
So what she came up with on hers is $1,430 a month.
$1,430 a month for child support.
Right.
That's based off of 2 children, Your Honor, not 1. In addition to that, our client testified to, after being with Mr. Breland for over 10 years. I'm sorry, I'm speaking.
I'm sorry. She was asking me a question. So if you just let me.
I was
well, we are agreeing to what she said. So if you would just allow us to speak for once, then we could just agree to that amount.
I would appreciate if you would not interrupt me. I have had about enough.
And that's
so please do not interrupt me, but I'm speaking.
Your Honor, if you
seriously
could
stop.
We agree to the amount that you have just stated, so I think that we could just avoid this unprofessional back and forth.
The most unprofessional here has been you. But
Ms.
okay.
Montgomery, what were you saying? Because is there a... That was
what I was saying is that my client had given testimony yesterday to how much Mr. Breland makes on a consistent basis. And even with that, we did not put the full amount because we do understand that he is a business owner. And so that is what we took into consideration. That is what I was going to say.
Yeah, so she imputed your client at $8,441. So it's kind of was like halfway in between what she said, and then she imputed or rather her client made $2,800. Does your client just have 3? Does she have 3 children?
Yes, she does, Your Honor.
So did you use did you count the qualified?
I did not include the eldest child because that is not Mr. Breland's child.
So you didn't count that as a qualified child towards her?
No, I did not.
And then, I don't know, Ms. Locklear, how much family law you practice, but she could also count that as a qualified child, which would make his child support go up. I mean, it's very little, maybe 20, 30, but anyway, because if he has any other children by anyone else that he pays support for, he has to be.
Next up, a defendant who treats the system like a suggestion box. He claims misunderstanding, technical glitches, and misplaced paperwork. Classic sovereign citizen energy. Lots of talk, no accountability. Judge West lets him speak, but her patience has limits. "Sir, you don't get to rewrite the law," she snaps. The crowd stiffens. This isn't a debate club, it's a courtroom. And the gavel? That's not a prop. When she drops it, his freedom goes with it. Another lesson learned the hard way.
Current on that support, but it would make his go down probably about the same. So, is there any... Are you going to go pro rata shares for anything out of pocket? Is that what you want to do?
Yes.
Okay, so this is based on out of pockets, Mr. Breland. You would pay 75% for anything out of pocket, and she would pay 25%. And Ms. Montgomery, we'll send you the form with the style. If you want to do like an addendum to add the other stuff specifics, you can get it to me. So he'll pay 75% of out of pocket. She'll pay 25%. And she has to give him the receipt for anything out of pocket within 10 days, and he's got 30 days to pay it. Is that good?
Yes.
He could pay that. Let's make it certified funds, or do you want Zelle or Cash App or something, one of those fancy things that I have no idea how to use?
And they've been using Zelle, I believe, before, and we could just do it that same way if that's okay with everybody.
Is that good with you, Miss Lusk? Zelle or Cash App or what?
Zelle is fine.
Okay, so out of pockets, he can do that. So, Miss Lusk, your attorney's going to tell you have 10 days. So if you go today for something and there's a copay, you have to send him a receipt of that copay, okay? So he can send it to you. But that doesn't include going and getting Band-Aids at CVS. So let's not get into stuff like that, okay?
Yes, I understand.
And is there, Miss Montgomery, is there any, so there's not a child that's like asthmatic or anything, that any sort of reoccurring medical expense. Okay. So,
No, Your Honor.
all right. So we will make it. So does he have that to pay for this month? Does he have it paid? Ms. Locklear?
What do I have?
So you're saying, will he pay the $1,430 this month?
Yeah.
I don't have it right now.
We can pay that on Monday.
Okay. Do you want it due out once? You want it on the 1st to the 15th to split it in half? Which do you want?
Can we do, we'll split it in half on the 1st and 15th.
Yeah.
So
Okay.
we'll make the first installation on the 15th then?
All right. But so all of it's going to be due this month.
On the 15th, right.
You make all of it due this time on the 15th. And after that, you got 1st and 15th. Okay.
Then comes the probation revocation hearing. A man who blames everyone but himself for his downfall. He rambles about bad friends and bad timing, hoping sympathy will outweigh his violations. But Judge West sees right through it. Her tone turns ice cold. You made your choice. Now face it. The words hit like a sentence before the sentence. Silence fills the room. This isn't drama. It's real life. Choices have consequences, and this judge makes sure those consequences stick.
All right. So now here's what I say. All right. So it's due on the 1st and the 15th. So that's not the 2nd. It's not the 16th. And the 1st and the 15th to me is kind of late. So make sure it's there on time. Okay. So don't
Yes,
put it
ma'am.
postmarked or anything like that. And make sure that if these things charge like a 2 or 3%, you kind of add that in. Okay. Because I don't like for
And I think that we're fine. I mean, we'll do it if you can order the 1st and 15th, but I think that, honestly,
That's what I'm
if we need to do it, one way or the other, it's
Well, this, I mean,
No.
this is the same thing I tell everybody on Summer Mind, so they make sure that they know how to get it there. And we're going, and Ms. Montgomery, in the event that there is a legitimation, anything like that, you could put in there that we will, that the judge hearing that can modify this in any way that they deem necessary. So if there's anything else, is there anything what do you want to do? And I want to go ahead and do this. So, video visits or something with a child. And here's what I typically say is video visits with the children. And that I like to say that both parties can videotape it. That way, if there's anything that's said that's out of line, mom's got proof that said it was out of line, and then dad's got proof that nothing was said out of line. So that's what I like to say, because I'm assuming that if there's some sort of a paternity and or legitimation, that I could foresee a guardian in the future. That's what I see. So, and most of the guardians that I have, they usually like that. Not videotaping it to encroach on their privacy, but videotaping it simply for the fact of seeing if there's something that's inappropriate said.
Your Honor, I agree with that. I just wanted to be clear that there is to be, I don't know what your ruling is going to be here today, but our posture remains that there should be absolutely no contact with Ms. Lusk from either of these two individuals is our posture.
Except for, the contact between her and Mr. Breland is going to be, what's the name of that app? What's the name of it?
Family Wizard, Your Honor?
Yes, our Family Wizard. And it will only be, and so that's a small fee, Mr. Breland. It's a small fee, Ms. Lusk. But so you will get an email, Ms. Lusk, from Mr. Breland.
Voice. Halfway through the docket, the courtroom mood changes. An identity theft defendant steps forward. Nervous, remorseful, trying to sound sincere. For a moment, it almost works. Judge West listens carefully. But when the details come out, the fake accounts, the stolen information, the sympathy evaporates. You stole from people who trusted you, she says, voice steady but sharp. There's no yelling, just disappointment. And somehow that cuts deeper than anger ever could. The defendant bows his head. Game over.
Say he has signed up for it. And Mr. Breland, you will get an email from Miss Luss saying that she signed up for it. So that's not going to be a violation, okay? Now, with that Our Family Wizard, Miss Montgomery will go more into depth with you, Miss Luss. She will post something. So the only thing you need to send him is the little Johnny. I don't know. Little Johnny broke a toe. If you want to let her know that little Johnny broke a toe, you could do that. And Mr. Breland, that you would just say thank you for telling me.
Okay, yes, ma'am.
That's it. Anything else, so that's just if there is an emergency, okay? Until another judge, till y'all do the legitimation, and then they will change that if they need to, okay? So that's emergencies only. And then if she has to send the receipt, she'll send it through there. And that also, I'll tell you, it'll say how often you check it. So I don't know that she'll have that much to say to you about it, but I would check it every day. So it shows if she sends something and you never open it, it shows that. Right. All right. But Ms. Montgomery, if you put in there that they can, now if there's conversations going on and you're recording it on FaceTime or Zoom or however you want to do these visits, that doesn't mean that the other parent sits there and interferes with these calls. Does that make sense? So if you set it up on Zoom or something, you set it up and you walk out. Now these children are
9 and 4.
9 and 4. Okay, the 4-year-old's attention is that a small fly. Okay,
Right.
You're not going to be able to keep the 4-year-old on there for long, and the 9-year-old probably not much longer because they're going to want to do what they want to do. So, what is a good time that they're not going to be enthralled in a game or television or dinner or something?
Monica plays video games all day. So.
So, Miss Lusk, do you know a time that you would? And I don't know. And I'm not going to say 30 minutes or an hour. We'll say like what? 5, 10, just a 10-minute, like, hey, how's it, something?
We can set up something. I mean, after school, I know is a good one. And then, if he wants to do weekends and talk to them, I know that they're anxious to talk to their dad. So I'd be happy to set that up.
So, Ms. Montgomery, what do you want to do? Do you want to leave it? Because I don't want them to have so much contact. You want a set schedule? What do you want?
We can do a set schedule.
All right, guys, this next one's rough. A young woman faces sentencing, her voice trembling as she begs for leniency. But the judge has heard it all before. You had every opportunity to stop, she reminds her. Tears flow, but justice doesn't pause for emotion. The audience senses the gravity. This isn't punishment for punishment's sake. It's consequence, pure and simple. When the judge delivers her decision, it's firm, final, and heavy. The courtroom goes silent. Lesson learned. Your choices echo long after your excuses fade.
We could do like 3 days a week. Like Monday, Wednesday, and Saturday.
All right, Mondays and Wednesdays, give me times.
I need time to get home from work. So if you could give me till about 7 or 7:30 p.m.
So 7:30 p.m. until 8 p.m.
Till 8. And what if there's a reason that I'm delayed, which I'm not saying that I will be. I'm just simply stating I've got work and I got to pick them up.
Absolutely. That's what things happen. Life happens. You get on Our Family Wizard, you send him a message. That's why he's going to check it between 7:30 and 8 to see if something happens. Just like life can happen with him, that he may say, I can't do it today because life has happened, and y'all could switch. Okay, that's in case something happens. And on Saturday, what's a good time for Saturday?
Let's do in the morning for now. Let's do like 11 a.m.
So like 11 a.m. to 11:30?
That'd be fine.
And that's a window. I'm not saying they have to talk for 30 minutes. That's a window. Okay. Now, also, I'll tell you this, and Ms. Montgomery will tell you this, that the way that you two behave right now is setting up to see how this is going to go in the future. Okay. So let's all be grown-ups. All right. So is there anything else, Ms. Montgomery, do you think I need to? I think that pretty much covers it, right? So we'll put it in place for 12 months, and we'll let the judge who's ever going to deal with anything else that's filed, modify it in any way that they deem necessary. And we'll leave it up that if something happens, if somebody needs to switch a day with the videotape, seeing things, that you two can agree to swap days, but, if you have to talk to her about something, Mr. Breland, maybe you want to let your lawyer call her lawyer. I hate to do that, but you may want to, or something, or you can email her, whatever. Okay. But through our family wizard, if something happens, you can email her, but it has to be about the children.
Yeah, absolutely. Yes, ma'am. I completely understand that. I just want to know why not 5 days a week? At least 5 days a week.
She says 3 right now, so just take what you got.
Okay, that's understandable.
By now, the tone has shifted from shock to reflection. The defendants came in thinking they could out-talk justice. Instead, they've met a judge who values integrity over theatrics. Each ruling feels like a reality check for anyone watching. No favoritism, no soft spots, just straight accountability. You can change your life, she tells one man, but you have to start by admitting what you did. That moment right there, it's the heartbeat of this entire courtroom saga.
Yeah, a legitimation.
I don't know why when I've been in their lives every day, but I get it. She wants to do this, so that's fine.
I don't either now, but you have your choice of a legitimation case. Whatever y'all decide to do, y'all can do it. 6 of one, half a dozen of the other. But anything else that you guys would like to take up?
Your Honor, we filed an affidavit for attorney's fees.
And obviously, we object to the attorney's fees.
All right, you want to file an objection, and I'll give you 10 days to respond. And
Yes, Your Honor.
what's the date? If y'all want to send me something, a proposed order at look at my calendar. Oh my God! Oh my goodness!
Also, I apologize for doing this. Can Miss Les tell me again what 3 days she specifically said? Because I wrote my notes times, but I didn't actually write down the dates. So can you tell me that again, Miss Les?
Mondays, Wednesdays, and Saturdays.
Mondays, Wednesdays, Saturdays.
Yeah. And obviously, if things happen, she could be flexible. Whatever.
Yeah, we can.
All right. So, about what is this? January. So, I know there's like holidays coming up. So, how about by February the 5th? Is that good?
Yes, Your Honor.
So, you got 10 days to respond, and then how about I expect if y'all want to send a proposed order really short and statute proposed order for both of y'all by February the 5th.
Yes,
Will
Your
do,
Honor.
Your Honor.
All right. Everybody else stay safe and healthy, please.
Your Honor, do you want us to also prepare the final order for
Yeah, you can prepare that. Yeah, you could prepare that, and if you want to put that stuff. And do you want to order, and then do you want our standard order, and then you could just do like a line 24, 27C addendums?
Yes.
Okay, so Miss Frio, email it to you with the style, and you could do that.
All right. Sounds good.
Miss Martin,
Your Honor.
do you have everything that you need, Miss Martin?
Are we still coming back on the 12th for the other TPOs?
I don't know. Was he served, or what do we?
One was served. The other, we still don't have confirmation.
Were we given a time for the 12th, Your Honor? I did not receive. I don't remember we discussing a time. I know we discussed a date for the 12th.
Did we do it in the afternoon? Did we do?
No, it was at 9:30.
It was 9:30. Okay. Did that change for you? Do you have something?
I'm so sorry. Can I just clarify something? Mr. Breland just wants to make sure that he's clear on this. So 3 days out of the week, and obviously we talked about the flexibility of the schedule. Monday, Wednesday, and Saturday is what we have.
Is that video chat?
That's video chat that he'll get to do with the children, not actually see the kids, correct?
Because they're on the video chats, right?
Okay, perfect. Just wanted to confirm that with you.
Until something else is filed, and then the judge, whoever hears it, it's the 12th at 9:30.
And so we did file the petition for legitimation and all that, so we'll just go before the judge on that and then have a hearing.
Did it get accepted? Got a case number?
Well, we filed it actually in this case too, last week before the hearing that we had scheduled for the 30th for both of the children,
So,
and it was accepted.
Did it get accepted there?
Yes.
Your Honor, this matter is not right before the court, and so it's not something that needs to be brought up during this hearing.
Right. No, I'm just going to see who that's assigned to for your own edification. Let's see. Who is 4 now?
All right, guys. As the final gavel falls, one thing's clear. Judge Raquel West doesn't just enforce the law, she restores respect for it. Every defendant walks out changed, whether they realize it or not. This courtroom isn't about humiliation, it's about truth. And the truth is brutal, raw, and necessary. From denial to acceptance, from excuses to accountability, this is justice in motion. So next time you think you can talk your way past responsibility, remember this courtroom. Because here, words don't save you, actions do.